Welcome back to Cannabis in Canada with Jason Wilcox. It's been a phenomenal month and quite frankly 60 days across Canada with what's going on. Everything from the raids in Edmonton, the information that was handed out, again in another province there with Glenn Price from the local, Winnipeg police that was, where they gave him the information to, again, try to shut down his dispensary while they're implementing dispensaries in places like Calgary. And a lot of this stuff is what I want to get in and talk about with a very special guest today, Micheal Vonn, who is the head of the BCCLA, which is a BC Civil Liberties Association, I believe of British Columbia.
That's right, BCC.
Welcome to the show, Micheal.
Yeah, thanks. Nice to be here.
Now your association is truly, I know a bit about your providence. You guys were very involved in the Insight case. You were interveners in Insight. You were also interveners in R versus Smith.
Yes, we were. Just recently, so when you were talking about what a historic time this has been in medical cannabis, that certainly has been a highlight for us. So we've been talking for well over 10 years as we explain to people that the outrage, essentially, of having Health Canada require medical cannabis patients to smoke their medication. If that's not an abrogation of your liberty rights, it's very hard to say what could possibly be in terms of medical autonomy. So that you have the government requiring you to take your medication in, for many people, the least helpful form. On the rationale of a harms argument where there was virtually, as we saw coming up through the courts, zero evidence, right? So this whole question of what do you have to, as the government, use as a justification to shape the discretion of providers and patients to medicate? That is a kind of an underlying issue in what is otherwise, of course, a medical cannabis issue specifically, but the whole question of medical autonomy gets raised in this matter, and so from every possible
To be fair,
angle.
just we can agree on this. I've looked at your constitution, and we could agree on this. It is an internationally recognized right and a very fundamental right to the core of what liberty is to be able to put into your body whatever you want, provided you're not hurting anybody else or yourself in the process, which is, a fundamental right to autonomy. If you think that eating 200 tomatoes is going to help you, as long as you're not hurting yourself or anybody else, it's not illegal to do it if you think it's medical. That's the autonomy issue.
It is the autonomy issue. Now, remembering that we essentially, well, not essentially, we lost the argument at the Supreme Court of Canada that you require a demonstrable harm in order to criminalize something. Yeah. We lost that.
Well, obviously they got Bill C-10, so.
Yeah, so, but from a civil liberties principle, from a human rights perspective and various other things, we want to keep hearkening back to the sense of it is an integral part of civil liberties to say the harm principle is key. If you are not hurting anyone else, you should have the maximum amount of autonomy to decide the fundamental questions about what you do in relation to a core.
Especially personal medical affairs. I mean, you're talking about everything from death to, just dealing with whatever, a sore back. It's still your right to your body.
Which is about as fundamental as it gets in terms of, and as intimate as it gets in terms of a right. Absolutely. So yes, we're very, very keen on medical cannabis issues, not only on the issue of medical cannabis, which has engaged the association, cannabis generally, but medical cannabis in particular in the last while, engaged the association for over 50 years. But again, as we're discussing right now, this underlying question about medical autonomy, which is, well, there is no Canadian that this does not touch. None.
So true. So true. Well, it does, because of course, we see this with medical patients, over 95% or something public approval for medical patients to use cannabis is because people have come to accept that even if the government states there's no medical value to marijuana, that there is something, because these patients are getting better and patients with cancer are beating it back. There's a lot of good stuff going on. But let's move on here to something else now. Now, a case that I filed on November 25th, 2013, known as the privacy cabafle there with, I filed it with Branch and McMaster here, and that was recently certified. So now,
congratulations.
Thank you. Now, just so everybody understands, this was announced by McInnes and Innes first, because there's a consortium of attorneys, or a consortium of firms, sorry, that took on this case, representing all 41,000 of you out there that were mailed letters by Health Canada. And by default, this is an opt-out case. You're all represented. So if the government of Canada decides to settle, which they often do once a case is certified like this, and you've already got the Privacy Commissioner agreeing with us, they usually will settle, or they could choose to spend another $100 million going to trial to defend and challenge the judge's disposition. What's your kind of take on, one, I understand the congratulations part, but what's the BC Civil Liberties take on when that happened, and also kind of the fallout now, like once this is done, does this set another precedence where medical patients should have a right to keep what they're doing silent at all times? I mean, this is it goes back to that right to privacy, which I'm sure is, you know, the autonomy is that big right, but that fundamental right to privacy and patients' rights as far as their medical records, you know, that kind of stuff. It was a very, some people would say it was an administrative error, but 41,000 letters going through all your staff, that's a little more than an administrative error.
Yeah. Well, now you're talking the language of the home of my heart. Certainly, the issues around medical confidentiality and medical privacy are key civil liberties issues, and have just managed to weave their way through my entire career, even pre-civil liberties, because I come from HIV work. So I certainly know the importance of medical privacy and medical confidentiality. And we're fighting this on just about every front, right? Right now, this particular privacy fiasco, tens of thousands of people involved, almost looks old-fashioned. Right? Paper was involved, right? A lot of people should have caught this one. I agree with you in terms of administrative error. There are several checks and balances that got missed on this. So it really was it is a huge problem, and how many people it affected. But right now, when I say it's almost an old-fashioned kind of privacy breach because it involves paper, most of what we're seeing right now are concerns about what databases are you on. What databases are you on? Who has access to those databases? Who can walk out of the door with the database on a key? Right?
And I'm sure what Michael's referring to here is, so our viewers understand, and we've been following this too here at CannabisCanada.ca, making sure that we address just where are they keeping the data, because that had to go through the public mailing system. That's 41,000 names. I mean, I know that our lawyers have been looking at this, and I don't know all the internal information, but where is that information now? Does airport security have it? Do local municipalities have it? You know, where does it end up? Or is it at the post office on some server? Like you said, that an employee can just plug in and walk home. And my fear is, once again, that 36,000 of those 41,000 patients were medical growers, and that was the biggest issue with this privacy breach, because some of the letters went to neighbors' houses. You know, the mailman now knows you're growing, you know, potentially, and that's what the extra smell of marijuana is. It opens it up for so much opportunity for one, that your confidentiality is breached, but you're also opened up to the potential for danger.
Right. And
that's where, you know, the risk to the person comes in, or the, you know, risk to the patient. And to me, that was a very serious part of the breach. I don't even think even now that Health Canada truly understands that these were growers, and regardless of the number of plants, you can't just expose them because there's just so much out there, because it's $1 billion crop, as they say, you know. And yeah, so let's look now to AccolAIDS. Now, I mentioned this John W. Conroy, QC, the Cannabis Rights Coalition, formerly the Coalition Against Repeal, are the ones who funded this, $260,000 to Mr. Conroy, and of course paid for the $70,000 injunction that is still in place right now. So first, let's get your thoughts on the injunction, and then we'll move on to the trial, because injunctions, just as I've said that before, guys, injunctions are only, I think, 20% of all, basically 2 out of 10 are ever won. Is that accurate?
I'm not sure about that particular figure, but it wouldn't surprise me. Irreparable harm is a high standard, so I'm not surprised by that number.
Yeah, well, of course, in the balance of convenience, and you're bang on irreparable harm, in the balance of convenience, they have to look at fire, mold, and organized crime versus the irreparable harm that would befall a patient if you just take away their garden and displace them and force them to try to go start buying somewhere else. So when they balance this out, the federal government didn't substantiate this, and the balance fell to the patients. and therefore the judgment went to the patients and was upheld under the appeals bench as well. So 4 judges have said there's no public safety in relation to gardens, and of course it's before Mr. Phelan, or Justice Phelan right now, and we look forward to that decision. But BC Civil Liberties, what's your position? I remember calling you in 2012, I don't know if you remember the phone call, and I said we're starting a coalition, and you guys, you informed me very clearly that when the time comes, there might be the ability for intervention. That would be at the federal appeals bench or SCC, as you did in Smith. So, you know, what's your thought? Because back then you even told me, yes, it was wrong. But I'm looking at what are your thoughts now that the government failed to substantiate their case, and really it's quite once again a mess on the federal government's behalf. They spent we've got the Freedom of Information Act request and proven it's costed over $1 million so far for the federal government to try and prove their case.
Right. Well, again, the Civil Liberties Association, we're in a sort of unique place because we not only care very much about the substance of these matters, right, patients' rights and how this falls out, but we're also very interested in how the law is shaped. So we're interested in these questions of what is the evidentiary standard when the government makes a claim of harm. That's very interesting because, of course, these are the tools that shape all of our rights.
Correct.
Right? So we want to make sure that those tools are sharp and that architecture works. So on every possible angle, we're interested in this. To just back up a little bit about what our position is vis-a-vis patients being able to grow for themselves. When we made, and we've made, I believe, 2 now, submissions to Health Canada when they were taking submissions on the new regulations. And we were adamant that patients required this. And we did some very simple number crunching. And again, I'm going to be telling you what you already know here, but just so you know our position, we did some very simple number crunching and we said, you know, here's how much it would cost you for a kind of a standard, completely untoward medical cannabis medication for a month. This is your average disability amount. This is the portion of what it would cost you for this one lone medication. There is no way, right? Typically, we don't get into socioeconomic rights. That's not kind of a usual civil liberties matter. But the idea of taking this away from patients who simply are going to have no recourse other than to grow for themselves because of the cost, if they are on disability or welfare or any of the other kinds of very low fixed incomes, right?
So does this remind you of the Insight case, and where it was very much the same, where addicts that shouldn't be on the street taking the chance of ODs was to try and reduce the death rate and disease and everything else that comes with addiction, and that was very much the same thing in getting Insight initiated, and I believe you having intervened in that. Do you see similarities between that and sort of some of the restrictions that we're seeing with the government?
Well, we often say, again, from a civil liberties paradigm, that there's more than one good. So when the government says peace, security, good government, crime control, and we say, yes, those are all goods. The question is, weighed in the balance with what?
Right.
And usually when we're talking about patient issues, we're talking about security of the person, life, liberty, and security of the person.
Section 7 of the Charter of
Exactly.
Rights and Freedoms. Absolutely.
And which is one of the heavy hitters. We don't try to weight them in terms of which are, you know, get priority, but Section 7 is, again, about as central as it gets. So when you look at that and you say, well, you can't just, we don't want to see these sort of invoked airily. There is some other reason why we need to abrogate from your right. If you're going to take away from a Section 7 right, you've got to have something very, very, very substantial. Again, because it does boil down to a sense of justification. All of our rights can be violated, if you will, or abrogated from all of them. Section 1 analysis, again, probably something you've come to know very well,
reasonable
right,
limits, yeah,
is essentially an argument about government justification.
Yeah, reasonable limits on Section 7.
Yeah.
I often say Section 7 is your right to cannabis, in essence, you know, and you have Section 1 reasonable limits on that. And if you pass the Section 7 test to, if patients, for instance, in this case, face, you know, persecution, if the justice agrees that you pass the Section 7 test, you move on to Section 1, which is reasonable limits on that right. So again, that is the fundamental right, and principally, both R.V. Smith and Allard are Section 7, Section 1 cases.
Yes.
That's why we're glad that the federal or the Supreme Court of Canada has spoken in R.V. Smith and said we can use cannabis in all of its forms.
Yeah.
And now that sets a very good precedence, because we've argued very much so that, again, we're looking at patients that are going to be, as you said, face persecution. There's Bill C-10, mandatory minimums for 6 or more plants. All this kind of stuff is very, very arbitrary for a plant that is no more addictive than caffeine, no more toxic than caffeine, and doesn't have a lethal death rate or dose like caffeine. So now with that being said, that's good, because BC Civil Liberties' official position on gardens, and of course, is to support it, and it's needed there. And I believe you have a position paper on your website that...
Yes, we do. Yeah,
okay.
Very extensive, 2 very extensive position papers that were issued when Health Canada was doing its taking submissions, in terms of its consultation process initially prior to the regulations, and then with the regulations out.
When you say that, because I don't know if you remember when we sent a letter to Health Canada. I can't remember which month it was. I believe in 2013, and warned Health Canada. And Mr. Conroy, it was a very extensive letter, warned them we were going to seek an injunction and to put them on trial. And you know, that was a warning before. So we all made our efforts, but now this stuff has been passed.
It reminds me, when we put together our submission, you want to get out of the regulation business in terms of your, providing individualized access through this process, et cetera, et cetera. You want to get out of that business. To everything else, you suggest bad, 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 bad. Right? I mean, it really was a process where, we weren't saying that everything about where they wanted to go was problematic, but you could see right from the outset how this was going to end up restricting access to patients. And so already we're starting from the wrong filter, right? We want to do all these things. No, start from this filter. What's going to provide access to the patients, right? What's going to provide access? And then look at, look at where you need to go. It just seemed like the whole exercise was pointed in exactly the wrong direction.
Yeah, well, this has been going on for 13 years, as we talked about before the coming on air. This has been an ongoing thing. The government doesn't mind spending millions and millions of dollars on taxpayers' money to fight in cases that they know they're not going to win. It's like in the Supreme Court of Canada. It's funny. I was there at the Supreme Court, and the Canada only sent 2 people to represent. And of course, we had about, I think, 9 lawyers lined up there. It was very historic to be there and to see that and to take part in it. And certainly what comes out of Allard, I believe, will be constitutional precedents for growing personal cannabis in Canada, starting with medical patients. And of course, if the federal government, for whatever reason, says, we're going to legalize, but everybody else can't grow but the medical patients, I believe that would open up a Section 15 constitutional challenge, because we're all equal before and under the Constitution.
Can I just say, adding to your piece here, that there is, as much as we say, of course, we want the tools to be sharp. These are the ways that we challenge the laws, and these are the ways that we protect our constitutional rights. There is something outrageous about having to defend every aspect of your medical rights through the courts. As you're pointing out, the government is spending a lot of money opposing access to medical cannabis for patients. And who bears the burden of that fight? The patients. Exactly. Right? Citizens are going to court to defend their own rights. And we are saying constantly that we would like to push the government on disclosing some of its legal opinions on how you thought this was constitutional in the first place. Because the responsibility of government is to take very, very seriously making charter compliant legislation. Because the way our system works is you have a presumption of constitutionality, right? But if you are putting forward legislation that has only a snowball's hope in hell of being found constitutional, then that's an abrogation from the rights of the citizens to be able to rely on the presumption of constitutionality. It should be very rare, because clearly there has been a problem. Well, and instead, in this field, it's the norm.
Yeah, well, I'm sure in Allard, for instance, they didn't see a federal injunction coming on their monopoly plan, on their MMPR. I would call it a monopoly plan, because it was to strike out the gardens, and the Liberal Party of Canada was trumpeting legalization, while their chief financial officer, Chuck Raffishi, became a millionaire off founding Tweed and then distancing himself from the company. There's little things like this going on that really bother me, and we learned this as we continued to go through, as we went through Allard. And most importantly, the backgrounder. You know, we have 1,200 Canadians that think they're going to be licensed producer, and the backgrounder said there'd be 51 licenses in fiscal years 1 and 2. I would note we're after fiscal year 1. There's only 23 or 23 or 24 LPs, so we're on track with that 51 projection in the RIAS report, which is the backgrounder for the MMPR. So let's not. I don't want to. This has been a bit of a long interview. I really appreciate your time. This is good stuff.
We obviously could talk about this for some time.
We could go on, but I know that I know you're a busy lady, and we have. Yeah, we definitely have a lot going on here in the city of Vancouver, and this ties into all the stuff we've just talked about. So I'd like to talk first off about the city regulations that have been proposed, good or bad?
Both. We've already heard there's been much saber rattling of we're going to sue you for getting out of your jurisdiction, you're not allowed to get into this, you're defying Health Canada, you're for all kinds of reasons, you're in trouble. That's what the city's heard. They have inadvertently, or they are going to, reduce access, certainly to edibles, which have been widely available in the city of Vancouver, regardless of what's been happening at the federal level for some time.
So just from a civil liberties standpoint now, why would you find that arbitrary?
Well, it's not arbitrary, it's ironic.
Okay.
It's ironic. Again, because we have the city stepping up to do something that we had hoped for. We support there being dispensaries. We say that part of patients' rights to equality, right? You're a medical patient, right? We've established that, right? This is medical cannabis we're talking about, that you have a right to have the kind of interaction that other sorts of patients have when they go to a pharmacy and they have a person-to-person conversation. How do I use this? What are the implications? All of those things. To say that something about your medication is stigmatized or dangerous or otherwise problematic, where you have to receive your medication by mail only, we say is an incursion on those patients' rights. So we have long supported the dispensary model. We think that's appropriate for medical patients, which is what we're talking about. So, so the irony here is, while supporting the model, they're reducing access to edibles for patients because they have, as you're well aware, declined to regulate edibles.
No, this is where my argument comes in. Now, the city certainly said, and everybody knows this, they said they did not want to regulate the product because they're not in their jurisdiction to do so, and they're certainly not in the Constitution, not within your jurisdiction. And now R.V. Smith has come out and said that we can have cannabis in all of its forms. The legislative arm has only given a Section 56 CDSA exemption, to all the patients. So there is no legislation around this yet, other than the city of Vancouver. And I believe that they're overreaching council's, powers, in accordance with the Constitution, because they're overreaching a constitutional decision in R versus Smith. What's your thoughts on that?
Well, what we don't know, Smith says you as a patient have a right to access in a myriad of forms. What we don't know is who has a right to sell and under what regulatory model. We don't know that.
Well, we do have licensed producers. To be fair to those guys out there that I'm against, is a monopoly. Just the licensed producer, mail order, as you said, and failure of frontline service. At the same time, LPs do have a clinic in St. Catharines where they do sell, their memberships, or they get their prescription. They have a doctor on site. You go in, you sign up, you see the doctor, and you decide what you want to get. And of course, it's a free sign up to see the doctor, and it's very hard for patients to sign right now. That's why every time they shut down a dispensary, they displace thousands, because they can't always just go back and get another prescription so easy. Some of them change doctors. As we know, BC is hard on healthcare right now. There's a lot of things going on. And my biggest concern is if you take 94 dispensaries, pop them down to 20 or 25, how many patients are going to get displaced as a result of quote-unquote regulating dispensaries? And even though that's within the jurisdiction of the city, the minute that they said we're going to regulate the product, they're overreaching, I believe, their limits as council. Right. So,
well, I think it's going to be very interesting to see what comes of the city's experiment. We didn't get everything that we asked for in terms of our submission. I don't know anybody who did. I think this is an imperfect model. We hope it's we hope it's like a prototype that's going to get shaped. And as I say, the lens that we should be viewing this through is one of what optimizes patient access. And so we were talking earlier about the spatial regulations, right? So for us to say, well, we have 300 meters and you're going to do this and you're going to do that, right? You need to map that to figure out if you've got neighborhoods that you are essentially going to make dispensary free. Because again, from the perspective, the appropriate perspective of access from patients' view, you have to say, if that is the result of your regulation needs to be modified, right? So that's what we've argued.
Good. So that's very much the position that I'm in, because my biggest concern, again, I'm a patient rights advocate and activist. And here I see once again, not only did they start with thousands of patients' gardens, but here they are again seeming to, for whatever reason, it may be in good nature, maybe the city just doesn't know what they're doing, but it needs to be brought to their attention that they're overstepping their bounds, at least in relation to R.V. Smith, and trying to ban these extracts. And I say this because patients like myself, I'm 22 years with HIV. You know, there's going to be a time when I'm in a wheelchair and I can't bake. And I represent these patients who can't bake. Cancer patients, MS patients, they can't go up and just bake.
You know, and we've had this discussion with so many people in the media who say, well, you know, certainly, what about those oils? Doesn't that cover it off, they say. And we say, not if you live in an SRO, not if you're in long-term care, not if you're in the hospital. The list goes on.
Precisely.
And then I think people really understand it when you say, could you go home right now and make your own Advil? Well, you know, maybe if you had the recipe, maybe it worked really, really hard. But why should this class of patients be required to do this in order to take their medication? Why should you have to do that because you are a certain class of patient? Especially
when the Constitution says you don't have to.
Well, especially when we've just had a Supreme Court decision. The courts will say, here's your right. But it is the legislature's role, and again, the feds have hardly stepped up at all here, except to say, okay, oils. So the idea, so they seem to be operating on the notion of, we will make the ingredients available to you. And you can do X, right? So it's very hard to see.
How does X not end up at Z, though? It's still going to be muffins in the fridge made at the end of the day. And I still don't see how, and the reason I say this, because if I took, I wish I could do this on the show right now, just took a muffin and got some oil and decided to go home and squeeze a bunch in there. It's very yucky to have to eat, but if that was a way, and patients will do that to get rid of the mask, the taste of the oil. But to have to do that, it's no different. You know, you take that, there's a muffin. I mean, the fact that the patient, at the end of the day, or if a child does get a hold of cannabis, the lethal dose rate, there isn't one. It's like them getting a hold of a can of pop. They might get a little, you know, messed up and go to sleep, but there's no real danger versus like alcohol or pills where they could stagger out on the street or drive drunk and kill somebody. There's a huge difference that we're looking at here, and I'm wondering if it's not more about the billion-dollar crop versus our civil liberties and rights as patients. Well,
I don't know. In terms of a motivation, I don't know. Even if you put this together and you've got a muffin that looks like a muffin, and if we've got medical health authorities saying, you know, that muffin would be attractive to children and we're concerned about them winding up in ERs, which happens, then the point here is, we've made this point, and we're not alone in this, cannabis is not plutonium. We try to keep substances out of the mouths of children in various ways, including packaging, regulation, like there's a way to do this.
And just to be fair, we do need to be fair though, all these kids who went to the hospital, went to the ER, have any of them been substantially hurt, or did they just get checked out the next day?
Oh, I mean, I have no idea. In terms of,
I would argue that likely they were checked out the next day, or even this very same night after being, you know, calmed down. And and of course, it's not always the best experience. And that just comes from, again, kids being silly. Kids also grab glue and huff it. They spray Pam in a bag and huff it. This is stuff that happens. I'm more worried about the drugs in the cupboard and the beer in the fridge.
Right. And so the point is, without, I'm not a particular expert in terms of how those things might equate. You sound like you're much better versed. But the point is for us that you, this is not completely new, right? So if you, even factoring in that there may be, and you could say we can even acknowledge that there might be a concern if you're taking your child into ER, if your dog consumes a lot of cannabis. We know this is not good for the dog, right? However,
Well,
it's not good for
the
you.
dog. It could be good for the dog. That's arguable.
Well,
dogs
depending.
do have an endogenous system, an endocannabinoid system, and so do humans. So it's medicinal no matter how you want to argue it. But that's just me being the activist side.
There you go. But if you were to take a quite large quantity, and dogs are smaller than humans, you could at least argue you have a potential problem here. But again, the point is,
your dog's going to go to sleep and then wake up hungry.
And wake up hungry. Eat all your chips. But the point here is, again, to say, what is it about this, other than stigma, that is making us hysterical about a problem that exists in a number of substances and factions and substances and issues across the board, medication-wise, cleaner-wise. I mean, there's lots of substances that we want to ensure are not taken inappropriately, right? And we don't go to this length to make sure that that happens.
That's why I keep going back to the billion-dollar crop. And then I look south of the border. I mean, I am baffled. We've been constitutionally legal here in this country for 13 years. Here the U.S. is legalizing and allowing dispensaries, allowing free and fair market. They're making tons in taxes. They have no violence. They have no fire, no mold, no gangsters. They just have a problem with people bringing stuff in over the state line because it's illegal. Right. But this is just examples of why would Canada force this sort of agitation and disposition on medical patients. Again, Health Canada, seemingly for 13, 14, well, whatever it is, 15 years now, they have been fighting medical patients. And now, once again, Rona Ambrose comes out and says, I'm outraged at the Supreme Court of Canada. What's her qualifications to be outraged at the federal bench, the highest courts in Canada? You know, what's your thoughts on that? I know it's a tough question, but...
I actually... what can you say? We disagree with Minister Ambrose. I think most people in the country disagreed with her take on this. As I've explained to the astonishment of ordinary Canadians all over the province and sometimes the country, that the idea that Health Canada required you to smoke your medication is what the Smith case is about. People find that outrageous, right?
Thank you.
Ordinary people find that outrageous, and they should. I think that, without getting into how much hyperbole, rhetoric, and various other things, we know we have a problem with the current federal government's view of medical cannabis. That's not any surprise to any of us.
It doesn't help that the second act or third act that Harper did when he was in office was to strike any medical research into cannabis and cannabinoids. So that was a very strange thing. We still don't have any research technically. I mean, there's people like Dr. Mark Ware and others who are doing their own research. But really, if you want to call it medical, then do the research and bring it back into pharmacopoeia so doctors can actually reference what they're prescribing. That whole gateway issue still, we could probably get into that. But for the interest of time, let's stay on the city here because these regulations, once again, now this also ties into vapor lounges. Now, we were talking about this before we came on air, and this goes back to displacement of the patients. Now, as you said, they need reasonable limits, reasonable access.
Yep.
But what if you don't have a place to smoke it? A lot of people live in non-smoking places. They access places where there's no smoking. And then the city and the police don't like it when you smoke on the street. And you immediately draw attention to yourself for potential robbery and potential persecution by police. Even though you're exempt, it doesn't feel good to be jacked up, searched, and held while they prove whether you're a medical patient. That's the problem of being caught in the crossfire of prohibition. So what's your thought on kind of the shutting down of vapor lounges that they would like to do?
We don't have a position on this that would allow me to say, well, we've analyzed this in various ways and done that kind of thing. But again, clearly we get many complaints from people who are medical cannabis patients who say, my apartment, I don't own my own home, my ability to medicate outside of, and these are my requirements, et cetera, et cetera. This is a habitual problem. And so, again, we're disappointed that we have sort of medical health officers who are fixated on this notion of the secondhand smoke and the various issues. Again, not that we should be cavalier about other servers and workers and kind of, in environmental issues in various workplaces. We shouldn't be cavalier about that. But again, we've displaced the patient from this equation so readily here. And this wouldn't be happening but for the fact that this were medical cannabis.
I'd say we also displaced the product, because when we're referencing cannabis in the same reference as tobacco, and tobacco kills and cannabis doesn't, we can't do this. We have to write separate legislation for cannabis, and study the smoke. Study what happens when it's scrubbed, when rooms are properly scrubbed. They do this for tobacco places. Those are with proper venting and air circulation. Air control quality can be brought up to par if given the chance. But my bigger concern is patients having to stand out in the rain, stand in an alley, stand on a neighbor where it bothers a neighbor, and lose their place, lose their housing, whatever. Their manager doesn't like the smell. All this stuff happens. This is just further problems that the city is applying, to medical patients. And I hope BC Civil Liberties will take up a position soon, and understand that we need these locations to go to, and not just 5 or 6 in the downtown core. Like you pointed out, we need them in respective districts, so patients who live in respective districts don't have to travel far just to use their medicine and not breach the bylaws of the city. Quite frankly, you can't smoke in a park. Like me, I have this problem. I go to the beach and they always try to tag me for smoking, but they kind of talk to me and then they just leave me alone. I tend to know how to fend them off a little bit, but I feel sorry for the patient that doesn't know what to say.
Yeah, no, absolutely. And again, this is not something that we don't know about. And we know how many people it affects. Well, we get a sense of how many people it affects because we know the number that contact us.
Excellent.
Yeah.
Excellent. Okay, now just last closing thing is Cannabis Day this year. Now, I'm sure you've gotten lots of information about this. Now, the City of Vancouver fenced off the back of the art gallery, citing that there was construction, and then surrounded the front of the art gallery with young police and this new event police unit that they have, which is a bunch of young officers, not the typical ones that do, I've been at these events for a decade, not the typical officers. And not only this, but they weren't going to allow tents to be popped up. And you're talking about a Section 2 assembly, a constitutional assembly that is completely legal. It's not right for the police to intervene, and this has been a decade-standing event. So then when unfortunately somebody decided to start selling, the police moved in, and knowing that there was already going to be a hug power issue. And of course, what led to that was patients and people at the assembly getting pepper sprayed who were simply bystanders as a result of a trigger-happy officer who didn't know how to follow his training in dealing with peaceful, assemblies or protests. I don't use the word protest because now with Bill C-51, that's a dirty word. So they say. So do you have any thoughts on the police taking that kind of that stance? Well, I understand it's a national holiday, but it's also a 10-year standing assembly that's been held here in Vancouver.
Yeah. We don't, again, have a formal position on this, except to say, obviously, from a police accountability perspective, which is very much at the core of civil liberties values, if you have been inappropriately subjected to force by the police, we want to hear from you. We want to help you file a police complaint. Those kinds of things, those sorts of mechanisms. But writ large, yeah, it's very hard to say. What potentially motivated the failure to achieve the permit to do everything that fell out from that. We have no particular insight into that, and we will be keeping our eyes on how demonstrations vis-a-vis cannabis are policed in the future, of course. Yeah.
Well, there you go, guys. Bert, other people out there, Reg, you guys have got pepper spray, Jay. Contact BC Civil Liberties, file your complaints, and let them know how you feel, so people can investigate what's going on, so that this doesn't happen again to peaceful protesters. Nobody should get pepper sprayed. Officers can use their muscle. There was more of them than there were people at the assembly. This is what I don't like to see, because we're a free and democratic society. This is not a Doctorian country, and I just don't understand the provocative nature of the police. They even use photo recognition to capture all the leaders, and that's what the government has said, that they're starting to even surveil or put surveillance on peaceful crowds. But to actually be that provocative, which is what got a lot of people going.
Right.
It wasn't just a number of officers, it was the new photo recognition radar or photo recognition camera that they were doing, and we've exposed all this, but I think it lends once more to a broader objective with this thing in Canada. But on that note, Michael, I'd like to have you back on the show in the future,
Yeah,
and certainly it's phenomenal speaking with like-minded person like yourself that is able to talk about the Constitution, and certainly what you guys do at BC Civil Liberties is phenomenal in sticking up for people's rights and personally their liberties. It's like, for me, that's the fundamental thing, the right to liberty. Thank you for coming on the show.
Thank you kindly. Nice
Okay.
to be here.
Stay tuned for more from CannabisInCanada.ca.